yeah, after that, it helps. I like the favorite.
Yeah, that's super interesting.
I'm excited. Yeah, this is my.
Let's
Do it. Stay in a reflection.
Very like I can just. Baby, wow. Like dealing with that. He's 7. No, he's a nice guy. Like it's just
Oh, dude, that's going on. That's going on my ceiling.
Me too.
I didn't think
It's just submitted. Actually trolling.
but so I think I need to definitely
Like
Yeah.
They can see all the rest. They don't, rather than shipping them.
That's been into the.
If you snore, feel free to go to sleep.
Come back.
oh, I see. I
No sympathy, no strength.
Oh, no, I knew the Rita.
We still have 3 minutes and we still have more wine and champagne in the back. So please, if you haven't got one and you want something, please drink it or you'll
You emphasize the students, it's free.
See my face.
Yeah, she said.
Yeah, I think that.
Maybe.
We should ask them.
I think since everyone's kind of settled, we might even start maybe a minute early before the hour. And it's just going to be an hour kind of sharp. The speaking and then time for lots of questions. So good evening, welcome. I'm the director of the Julius Stone Institute. I think I know some of you from courts or foundies and maybe even jurisprudence classes. So we're welcome. I haven't met you. Welcome. And this is for me to say, I'd like to acknowledge that the University of Sydney was built. I should mention that the University of Sydney was built on the stolen lands of the Gadigal people of the Eora Nation. I want to pay my respects to their families and elders and note that their land was taken without consent or compensation, and they never ceded their sovereignty over them. And I acknowledge your ongoing struggles for voice, treaty, and truth. And Tonight, as everyone knows, we're really delighted to have Justices Michael Kirby and John Baston giving their reflections on jurisprudence, the jurisprudence and impact of Julius Stone. So these flimsy plastic holders couldn't hold up the weight and gravitas of Julius Stone. So he's on a very sturdy chair. So if you have a chance later, if you haven't already, please go and have a look at Julius Stone. For those who don't know, Julius Stone, AO, QC, was the Challis Professor of Jurisprudence and International Law at the University of Sydney from 1942 to 1972. So a remarkable 3 decades. Later professor at UNSW. And he wrote 27 books in his career. And so that's books, not articles. And I've raided our libraries upstairs for props to give you a sense of so imagine this, and then add 26 more on top. This is what he did during those years in his career. And as we're going to see, he didn't do it alone. That would be an inhuman task, and he's had assistants, and we'll hear some more of that. And not also he's influential as a scholar, but also, as we're going to talk about tonight, as a teacher. As we hear from our 2 distinguished guests. And before I introduce them, I just want to add as well that tonight is really the start of a reconnection to the spirit of Julius Stone. So an important part of his time at University of Sydney was working with students working with him on his scholarly projects. And we at the Institute are really trying to now kind of re-engage with students as we've kind of, the Institute's has many seminars and events talking about legal theory with scholars from around the world, but we don't really have our students kind of engaged and integrated into that. So tonight is just the first step of bringing everyone back into legal theory and what we do, and maybe we'll hear a bit about if legal theory matters, and if so, why. It's an open question. I teach it, and it's I don't know the answer. So first we have Justice Michael Kirby, graduated from law in law at the University of Sydney in 1962, served as a solicitor and barrister till 1975. He then became a deputy president of the Conciliation and Arbitration Commission, chairman of the ALRC, judge of the Federal Court of Australia, president of the New South Wales Court of Appeal, and justice of the High Court of Australia. 1971, he was awarded an LLM degree with first-class honors based on a dissertation on Marxist views of law, which I'm very interested to hear more about, which grew out of his work for Julius Stone. And Justice Kirby has often referred to Stone's influence on him, including his exposition of the leeways for choice enjoyed by judges, particularly in the common law tradition. And we're also very fortunate to have Justice John Baston, graduated with the Stowe Medal at University of Adelaide before obtaining a BCL at Oxford University. He commenced his career as a teaching fellow at the University of Chicago Law School, followed by a career as a lecturer, a senior lecturer in law at the University of New South Wales. And in the 1970s and 80s, he played a key role in Sydney's Community Legal Centre movement and a founding member of the Redfern Legal Centre. And then as a QC, he spent 23 years at the bar, 13 of those as QC, frequently accepting briefs pro bono for the Redfern Legal Centre, including cases on a novel concept then of native title. Justice Baston then served as a judge of the Supreme Court of New South Wales and a judge of appeal since being sworn in on the 2nd of May, 2005. And since his retirement, Justice Baston serves as an acting judge of the Court of Appeal. So I'll now turn to our 2 distinguished guests, and I think they'll speak a bit of their own thoughts for 10 or 15 minutes each, and then we'll have time for questions. So let me pass it over.
Thank you very much, Director, and thank you to John Baston for being here today. None of you have probably seen Justice Baston in work as a barrister, but he was a wonderful barrister. He was not only a distinguished academic, but he then played a part in organised law reform, and he then became a barrister acting often in areas of law that were of interest to me and in the courts important to me in administrative law and public law generally. So it's a great pleasure and privilege for me to be with him today. As has been said, I acknowledge the Indigenous people of the land. I tried to think about it in the manner of the New Zealanders. If you go to a conference in New Zealand, they have an acknowledgement of the Maori people, tēnā koutou, tēnā koutou, tēnā koutou katoa. And it's a sincere and rather solemn moment in which they reflect upon the wrongs that have been done to the First Nations people. And I think we have to learn something from the way it is done there and not treat it as a perfunctory matter, especially in a law school where many of the wrongs that have been done have been wrongs deserving of jurisprudential and philosophical analysis, and they have been done by law. And it's therefore important that we reflect upon that fact. Nothing in Julius Stone's lectures to us back in the years 60, 61, 62, when I had him as my professor of international law and also of jurisprudence, nothing that he spoke about at that time that I can remember concerned the First Nations people. And I saw in the entry on Julius in Wikipedia that reference is made there to a statement attributed to another very distinguished professor, Professor Ben Saul of this law school, who is also a United Nations rapporteur on terrorism, a very important public lawyer, of Julius Stone's views on Israel and Gaza. And I'm not going to talk about that. We never talked about that back in those days. We never talked about self-determination of peoples. We never talked about the First Nations people. We certainly didn't acknowledge them in any way, and we denied their rights to land and other rights. And that was the time. So I'm not going to go into that subject unless I'm dragged there by somebody in the audience, and it may come up indirectly as a result of my comments. First of all, I went looking today to the successor volumes to Province and Function of Law. That was the great book that Julius Stone published at about the time that he came to the University of Sydney from the University of Auckland. That triptych there is on display outside the Dean's office in the University of Auckland because Julius Stone was the Dean of Law at Auckland. Julius Stone, although he had a brilliant academic career in the United Kingdom and then at Harvard, could not advance any further, and in particular in the United Kingdom. And it was later found that this was because he was followed around by a referee who had given a reference for him, which was very hostile to him for his support of a homeland for the Jewish people after the terrors of the Holocaust. That was an indication of the sorts of attitudes that existed at that time, even at that time after the Second World War, when the terrors of what the Jewish people had exceptionally suffered were becoming known. So it's an issue that was certainly very much in his mind, but I'm here to speak about the impact that Stone had on the Australian legal system, because ultimately he got the job in Auckland, and then with some hostile attitudes on the part of Australian academics, he came to Sydney, and he came not as dean, but as the professor of jurisprudence and international law, the Chalice professor. And he taught classes in the third and fourth or final year of the LLB course. And it was in that capacity that I first met him. He gave me a chance in life. You know that film by Peter Weir called Dead Poets Society, which is based on the Scots College. I see my dear friend Alan Cameron there, who went to Scots. You remember that passage in that film? It's a wonderful film. If you haven't seen it, you should see it, of the teacher getting on the table and telling the students, carpe diem, seize the day, make the opportunities. Well, Julius opened an opportunity for me, and it was one which was very influential in my life, and I therefore pay my respects to him today, and I'm speaking out of those respects and indeed my love for Julius Stone, for what he taught me and for what he did in this law school. The important thing for this reflection is that Julius Stone came to Sydney at a time of profound conservatism in the judiciary and legal profession of Australia. It was a conservatism sincerely believed and practiced that the law would have lost its meaning if it didn't pre-exist before a judge was asked to say what the law was. In other words, the purpose of judges, who were then much more important in our legal system because of the common law dominating the system and not the statute law, the judges had the task of finding and declaring the law. I remember a teacher in first year told me that the view was that the judges found the law by looking into their breasts, because they brought the law, the common law, to England in their breasts. I think that meant they brought it, because there were no women judges, they brought it in their hearts. But I thought of looking down there trying to find where the common law was and what it meant. But the notion that was propounded by the judges, virtually without exception, indeed I would say without exception, until about 1975, was that the law pre-exists, but that the skill of the judge is to find the law, and that doing so merely requires particular techniques. But you mustn't think that the judge makes the law. The judge is merely using techniques to find the law and to find it out of the interstices of all the law that has gone before. In other words, it has an objectivity, and it objectively exists and pre-existed. And the job of the judge is to find it and declare it and apply it, and nothing more. Julius Stone was revolutionary. His view was revolutionary in Australia. There was nobody else, I think, at that time who taught a different point of view. The professor of jurisprudence at the University of Melbourne was a very distinguished academic, Sir George Peyton, but he didn't teach this point of view to the Melbourne students, but Julius Stone did. What Julius Stone suggested in his writings and in his lectures was that this was a fairy tale, that this was simply a hypothesis, and it wasn't what judges actually do. When judges actually go away, having heard the argument, and determine how they will decide a case, they have what Julius Stone called leeways for choice. Leeways for choice. It was a phrase, I think, taken from Radbruch, the Austrian professor of jurisprudence. Judges have a capacity to find in the uncertain ambiguities of the cases that went before, leeways for choice as to how they will come down in deciding a case. Now, this was, not to put too fine a point on it, heretical, and it was resented, and it was objected to, and it led to Julius Stone facing quite a lot of opposition in the practicing legal profession and the practicing judiciary. Judge and co, which is how not dicey, but how jurisprudence professors in England in the 19th century described the organised bench and bar, a conservative group of people who were propounding this rather conservative view about the law. It's not something that the judges can make or develop. It's simply to be found and declared. Julius taught this is simply fairy story, and therefore there has to be an alternative proposition. And the alternative proposition that he propounded was that judges have to find what the previous law has been said to be, but in developing and expressing the law, they have a positive function. And that was what he called leeways for choice. And in his book, Legal System and Lawyers' Reasoning, which was one of the three successor volumes to Province and Function of Law, which he was writing when I was being his student in third year and fourth year at the law school. There's a whole section, many references to leeways of choice, and that was what Stone was teaching. Our Chief Justice at the time, Sir Owen Dixon, a very great lawyer of this old view, was, as it were, thesis, and Stone was antithesis. And we, as the students, were faced with this dilemma. Do we ignore what our professor is saying, or does it have persuasiveness? And I was certainly of the view, and it was a view that grew in the legal profession, the legal community and academia, that Stone was actually right, sociologically, practically describing what judges do. It's important to realise he wasn't saying judges can just go away and make it up and hang the previous law. They are bound within strictures that are left by the previous law, but they have a leeway for choice, especially the higher up in the hierarchy of courts. They have a leeway for choice, and that is as it has been, as it will always be with the common law, and we shouldn't be propounding fairy stories. We should accept that reality. He described his theory about leeways in terms of the sources for the leeway, which were sources derived from the ambiguity of the system and the many cases, thousands of cases on the law, which had to be synthesized to take them to the next level with a new problem which was unforeseen before, and that the skill of the judge was to do this in a forward, inclusive manner of reasoning. The result of this, Stone said, was that the job of the judge is to acknowledge candidly the ambiguity of language. He might have added, but never did, the special ambiguity of the English language, which is a marriage of the French language of the clerks of Henry II and the Anglo-Saxon Germanic language that preceded the arrival of William the Conqueror. But this joint language is a very ambiguous language. There's always two words for any concept, and that gives our language marvelous variety for literature and poetry, but a devil of a problem in the law. And Stone said, you just can't deny this. This is what happens. And so that's what he taught us, but it was heresy. It was an outrage. It was shocking. It was disgraceful. And it was objected to, but Stone just sailed majestically on, teaching it to us, the students of the Sydney Law School. It was an exciting philosophical difference, but it was also exciting professionally as well. And so the three things that I learned from Professor Stone at that time were, first, that the law did not pre-exist for every problem. It was being discovered and expressed by the judges. Second, that the judge has a positive role in expressing, and that is simply in the nature of what judges do. And third, that if you think everything can be fixed up by Parliament, if there is a gap or an ambiguity, then you're just wrong. That is not what happens. And I certainly learned when I was in the Law Reform Commission, if it is not a priority in the government or the public or the party's program, it just won't be addressed. And therefore, who is to address it? Who is going to deal with these gaps and ambiguities in the law, except the judges with their leeways? Now, there may be an opportunity in the course of our discussion, Justice Baston and I, to give a few practical illustrations of leeways we have had. One can be given immediately, the Communist Party case. He could not, the judges, including Sir Owen Dixon, could not have decided that the Parliament of the Commonwealth did not have power under the Australian Constitution to ban the Communist Party and proscribe its members simply by looking at the way the defence power and other powers had been interpreted. They could have gone that way, but they didn't. And they didn't because of the fact that Dixon said history, and not only ancient history, has taught how dangerous it is when governments can impose legal restrictions on people by reason of their beliefs. And that was a wonderful decision, one of the greatest decisions of the High Court of Australia, but it was not a decision that was founded on a purely linguistic examination of the previous authority. It was a decision based on deep values of the legal tradition of the English common law, which he discovered and expounded. So Julius Stone gave me a chance to work on his successor volumes. And in fact, I didn't work on the successor volume, Legal Systems and Lawyers' Reasoning, which contain many discussions of leeways of choice. but on his other volume, Social Dimensions of Law and Justice. And in the foreword to that book, he wrote, after giving tribute to Tony Blackshield and other people who worked with him, like slaves we were his slaves, he said, Mr. M.D. Kirby, BALLB, Sydney, gathered and organised much material for the first draft of Chapter 10 on Soviet Marxist views about the withering away of the state. Though he will probably not agree with the themes and conclusions which there emerged, the clash of ideas with him during writing was an invaluable prod. So that was what I was reduced to, an invaluable prod to Julius Stone. But he introduced us to the Australian Society of Legal Philosophy. Its slaves were allowed to come along there and sit in the presence of the great and good. He introduced me to many overseas distinguished professors. He put me in touch with, and I worked with, my subsequent lecturer and friend, Professor Ilmar Tamerlow, and he got us to work on his drafts and prepare them with oodles of footnotes for which he was famous or infamous. And he introduced us to the Internationale Vereinigung für Rechts- und Sozialphilosophie, the International Association IVS, and that became my link intellectually to a great movement of scholars from different traditions that Stone had taught. He was a very great teacher. He was a very great scholar. He was a very busy writer. He wrote a lot of things, and he had a great influence. And some, I forget who said it, but some say, if you want to see the difference between the Dixon Court and the Mason Court, you simply have to go to the Mason Court and you will discover that all of the, virtually all of the judges from Sydney on the Mason Court, who were the majority of the court, had been students of Julius Stone. He had a very big impact. So, Cole, legal academics don't get paid very much. They're very undervalued in society. They are neglected and sometimes unloved. But their rewards come not in another life, but a bit later in their lives when their students come along and give tribute to those who've taught them really deep fundamental principles. And one of those is leeways for choice. And if there's time, I'll give you a few good, hard, concrete examples. Now I pass over to my friend, colleague, and much admired judge, John Baston.
Thank you, Michael. Thank you, Cole, Imogen, and your colleagues for the invitation to speak tonight. I too acknowledge the Gadigal of the Eora Nation, who were dispossessed of their lands on which we meet without due process of law and some generations ago. In one sense, I fear that I am here under false pretenses. I studied law at the University of Adelaide and not here in Sydney. Unlike Michael and many other distinguished judges, lawyers, and academics in New South Wales, I was not brought up on Julius Stone's seminal text, The Province and Function of Law. My introduction to jurisprudence was H.L.A. Hart's The Concept of Law, of which Professor Stone was somewhat dismissive. However, I later broadened my exposure to sociological jurisprudence and the American realist tradition while spending time at the University of Chicago and later UCLA. My personal contacts with Julius were in his later years when he was a visiting professor at the University of New South Wales Law School, where I was a lecturer. Whilst at UNSW, he wrote his last book, Precedent and Law, which was published in 1985, just after his death. I'd like to refer this evening to an area of law which is of fundamental importance to the good government of a modern society, administrative law, and to a discipline which largely underpins it, namely statutory interpretation. As to administrative law, Murray Gleeson, in an edited collection of essays, Julius Stone, A Study in Influence, fairly noted that the province and function of law reflected the times in which it was written. Gleeson observed that modern administrative law is not foreshadowed. That, however, is by no means the whole story. In 1964, Stone published an article in the University of California Law Review entitled The 20th Century Administrative Explosion and After. I'm not sure what the last two words referred to. Harry Whitmore, in an essay in honor of Julius in 1983, picked up that theme but inserted the word law, so that his title read The Administrative Law Explosion. I shall return to Stone's 1964 article in a moment. As to the second part of the topic, statutory interpretation was by no means a central theme of the province and function of law when published in 1946. However, it was not ignored. Chapter 7, dealing with fallacies of logical form in legal reasoning, took issue with the idea, clearly under threat even in those days, that the civil codes enacted in France and Germany contained the answers to all legal problems, which answers could be identified by a form of deductive reasoning. Stone noted the method of interpretation which asserted itself under the code justified that expectation. The legislator's will was held to be the exclusive source of law. If the text of the code was clear in its ordinary meaning, that will was found in literal interpretation of the words. In conflicting texts, the later one was preferred. Where it was not clear, or the conflicting texts were contemporary, that will was sought in the spirit of the law, what Earing called logical interpretation, and what English courts term the policy of the act or the ratio legis. Stone did not describe the view, and it's one which Michael has been talking about in his talk. He didn't describe the view that the judges discover the law by logical deduction from legislation or precedent as the fig leaf of the common law, although that is a phrase which has later been applied. But he was adamant that judges exercise choice in cases involving the general law, where a principle was derived from one judgment dealing with a certain factual situation and applied to another different factual situation. Similarly, he argued that to pretend that a legislature had foreseen the precise boundaries of the operation of a principle stated in a statute was to indulge in fantasy. This was the problem I understood that faced Michael, who searched for the law in his heart but couldn't find it. I think he meant his heart. As to the second part of the topic, statutory interpretation was by no means a central theme, but the province of law involved quoting, for example, from Oliver Wendell Holmes' statement that the life of the law has not been logic, it has been experience. But the meaning of that aphorism will be much better understood if read in its historical context, as Stone demonstrated. Turning then to administrative law, Stone's thesis in his 1964 article bears revisiting. One consequence of the administrative explosion was, in Stone's words, that the traditional separation of powers has seemed threatened at its foundations. he preferred a translation of the separation of powers doctrine into a division of functions. As he rightly understood, one important function of government administration was to determine legal rights and duties of citizens in a manner characteristic of judicial, not executive power. He identified the growth of the administrative state, which he described as the virtual establishment of a fourth branch of government, a concept we have seen repeated many times since, as resulting from shortfalls in other institutions. For example, he wrote, the shortfalls in legislative aptitudes are broadly of three kinds. One, limits on time available. Two, limits of specialized knowledge required in new areas of legal control. And three, limits on organizational aptness for exercising continuous supervision over legal development in areas where detailed rules or even policies must grow by experience. We can surely recognize the underpinnings of the Chevron principle of judicial deference to agency rulings in this description. Yet in June this year, the US Supreme Court largely abandoned Chevron, arguably because they did not see it as fitting the traditional tripartite separation of powers doctrine. Stone, I should add, was anxious to avoid escaping the straitjacket of a tripartite separation of powers by adopting a quadripartite one, by, in his words, dogmas requiring that administration always be divorced at all costs from the executive power. Nor did he see ready answers to the necessary forms of control. Stone noted the inadequacy of tabling delegated legislation before a legislature, where it will not be rigorously vetted for consistency with statutory policy, a factor of the legislative shortfalls he had identified. And the inadequacy of relying on judicial review, noting that the judicial process is not apt for controversies which are polycentric, that is, which involve numerous foci of dispute, the decisions on some of which may depend on how others are concurrently determined. There is no doubt that the problems from the 20th century explosion of legislation still haunt us, indeed in a far more extreme form than they did 60 years ago. They are part of the working out of the full scope of the modern and still adapting administrative state. And as Lisa Burton Crawford has recently discussed in an article titled The Problem of Complex Legislation, they cause us to reformulate essential values we think of as inherent in the rule of law, such as access to and comprehensibility of legal texts. Mind you, I doubt that the law was much more accessible to the lay public when it was mostly extracted from decided cases rather than statute. However, there is no doubt that the adaptation of conventional theory, requiring identification of the social values which the law is seeking to maintain in the search for justice, is part of the field of sociological jurisprudence, if not formulated, at least promoted by Julius Stone. To a suggestion that he has not addressed specific issues that we now see as of central importance, he would have raised a quizzical eyebrow. His fundamental point was that the law is a dynamic system which will and should change with social conditions. His work continues. Thank you.
Thank you both for those fascinating and humbling comments. Great, so we have time for some questions. So who'd like to go first? Well, students first, Michael. Let you go. Yeah, and do you want to pass the
Thank you both for your presentations. I have a question for Justice Kirby. You spoke about judges exercising a positive role within the bounds of their leeway of choice. And when judges are making these decisions, they may be influenced by their own personal experiences and their values. And so I wondered, to what extent do you think the public should be aware of the experiences and the values of judges? And if they should be, what are some ways that those values could be communicated to the public?
That's a good and rather familiar question, and it's a reasonable one. If you look at the index to Stone's book on legal system and lawyers' reasoning, under leeways, it has its closed systems, dangers of excessive uncertainty found within the precedent system itself, functions and effects of the House of Lords and inadvertence to, interplay of, and logic, mutual delimitation, logical demonstration of, Lord Coke, need for continued awareness of leeways, 19th century neglect of, in the notion of ratio decidendi, profession of, right not to follow precedent as, stock taking of, with under indeterminate reference. So all of those show the variety of issues that he was addressing. I said that I would mention some concrete examples. As I've indicated, the concrete examples present you with a problem where your view of justice may take you one way, but where the legal parameters forbid it or don't look comfortable to that way. A good illustration of that is an administrative law case, B, against the Minister for Immigration and Ethnic Affairs. It's a case of two Afghani boys of the Hazara minority who claimed through their lawyers that they were not within the obligation in the Migration Act 1958 to have a visa before coming to Australia, and as a consequence of which they and their parents were locked up. There was no argument about the parents' obligation, but the contention was put to the courts that so grave and substantial is the interference with liberty against two young boys aged about 7 and 9 who would not be the normal person who would get a visa or know about a visa or know about a visa system, that the act should be read down so that it applies to persons as adults, but not to children. And that was a decision, a view of the Act that was adopted by the first instance judge and by a majority in the Intermediate Court of Appeal. And it came to the High Court. Justice McHugh and I granted special leave to appeal in the case, came up to be heard by a full court. And at the end of the case, when I went off, I thought leeways for choice. This is something that has attracted the judges below. It's an arguable proposition. You sometimes do read down statutes, and you do so where important issues of human rights or individual rights are concerned. So that sounds pretty good. I think I'll affirm the decision below. But I then went into my room, mein dunkles Kämmerlein, and I had to try to see if there was any obstacle. And the obstacle was presented by two pieces in the transcript. One was that during the argument in Parliament for the insertion of persons, the Attorney General's Department, rather bravely, I think, sent across officials to Parliament to say, if you go ahead with this, almost certainly Australia will be in breach of the International Convention on the Rights of the Child. And that came to the Parliament. The minister was Mr. Jerry Hand, a Labor minister. Do not think that these provisions are only enacted on the proposition of the coalition governments. And he said, we don't care about this. We'll make this very clear. This is a decision of the government. We will decide who comes into Australia, and person means person. And if you've got a problem, that get real. He didn't quite put it so disrespectfully, but essentially that's what he said to Parliament. But there was another more fundamental problem from a lawyer's point of view. The Act contained provisions for the searching of children in detention. If the children did not fit within person for the purpose of detention, why would you make provisions for their searching? They wouldn't be in prison at all. And therefore it didn't fit together. And therefore I had no option but to go with the rest of the court and to spare the readers of my dissents and other dissent, because that was the better view of the legal obligation. So the answer is, you can't entirely set aside or disguise or ignore your sense of justice which reflect your values. What you have to do is see, does that still work, or am I simply going off on a tangent of my own, in which event you have to think carefully before you do that. And also you have to justify it, and you have to explain why you feel justified to do that in the face of contraindications. So I think the answer to your question is, you can't avoid your values. And in the view of many people, you shouldn't try, because your values will be speaking to you sometimes of the values of the law. And but it's not an unlimited palm tree justice job. It's a job of lawmaking within restrictions. And the finding of the restrictions and the expressing of the restrictions is the interesting bit. And even great judges like Sir Owen Dixon, in the case of the Communist Party and the Commonwealth, really referred specifically to history, and not only ancient history teaches us that governments, given a power that is claimed here, will make rulings that are inimical to fundamental freedoms, and the job of the court is to try to prevent that becoming the law of the Constitution.
Just following up on that exact theme, it sounds like in your account that the values of Sir Owen Dixon, or the values of the judge, are what make the law, and that the judge themselves is not, in fact, making the law. So I just wonder if that puts a spanner in the works in the kind of dichotomy that you put between the conservative view of jurisprudence that you outlined and that of Julius Stone. Nice try, but it doesn't really work, because the judge is expressing the values and doing so in a way that explains why, if he might have different views, he can't give effect to them. So the judge is still the actor. And that is the nature of a common law system. Indeed, it's probably the nature of all systems, but we're more honest about it. Keep in mind that the Napoleonic systems, which include Japan, China, and Asia and other parts of the world, do not permit dissent. They do not permit it. They require the judge to be la bouche de la loi, the mouth of the law. That's all a judge is. But Is that possible in any legal system? It's pretended in the Napoleonic systems, but we have more honesty. We feel it very important for our judges to express the honest processes of their thought. I'm sure there are many brave and wonderful judges of the Napoleonic system. I've known some of them. But when you tell them about our system and how valuable is the right to dissent and how that can sometimes contribute to later judges seeing the same problem in a different light, very few of them want to have a right of dissent. They rather like to resort to the pretense, which is what Lord Reed once called the fairy tale. The fairy tale that the judge approaches Aladdin's cave, has the magic password, and then lo and behold, abracadabra, down comes a decision, which is not the decision of only of the judge, but the decision of the law. But this is why, Stone, please come back with me in your minds, if you can, to the age that I'm talking of, the 1950s, 60s. Stone, in terms of that age, was, I think, a revolutionary. I lived through that age, and I knew the enormous respect that Sir Owen Dixon had. But I don't think it is true to say that judges don't have values and don't give expression to their values. It would not be really possible, and particularly with the English language, because of the fact that the words will themselves leave leeways for choice, if I can use a phrase.
Can I add 2 points to that? One is that when talking about personal values, Sir Gerard Brennan always used to say that the judge should look to the enduring values of the law. And they were the values that he perceived as being vested in the legal framework, the institutions, the cases, and so on. I have a problem with identifying a single set of enduring values which would be recognized throughout a multicultural community. But nevertheless, the idea is there, I think. The second point is that as Michael gave you an example, you were understanding and nodding when he explained his process of reasoning. And I think that's because you have been taught enough law to obtain from his description exactly the nature of the process which a judge is undergoing. You can all do it, and you do it in your exams, but it's not, as it were, a carte blanche. It is a highly constrained exercise, and the values include stare decisis, certainty, understanding the law. They are public values, and they are part of the access to justice, to the rule of law, which everybody should be able to understand as best they can. And those values have nothing to do with personal preferences, requirements that you be called he or she or it, or anything like that. They are much more fundamental values.
Thanks very much for your comments. I'd actually quite like to hear from Justice Kirby on his dissertation about Marxist views of the law. Perhaps the sort of...
We'll have to give another seminar with champagne, other nuts.
But perhaps the sort of old school Ashokanian view of law as a superstructure has maybe fallen out of favor. But I wonder what role there still is for sort of critical jurisprudence more generally in understanding the way that the law works today.
I think there's a lot of room for critical jurisprudence, because unless we question hypotheses, we cannot be sure that they are right. And I support critical jurisprudence, and I rather like crits. They are people who will question. What is objectionable, in my view, is to say one thing and then do another. I think it's much better to try to be truthful to yourself and to the society you serve. I had one case, my very last case in the High Court of Australia. It was handed down on the very day that I retired. It was handed down just after I had had a big ceremony that packed the #1 court. I won't get into Mr. Trump's view of which is the biggest crowd and so on, but it was a big crowd. And then I went down and handed down the decision in Wurrajul against the Commonwealth. Now, Wurrajul was the challenge to the Northern Territory intervention. If I could have gone forward in my mind, I would have known the terrors and wrongs that were done by the Northern Territory intervention. The latest issue of the Monthly has a story, a large story on the intervention. It was not a good look and it wasn't good policy. It came about as a result of a Royal Commission of Inquiry done by Mr. Wild, the Solicitor General of the Northern Territory, who said, whatever you do in this matter to respond to the problems of family violence and breakdown that I have portrayed in this, you must consult the Indigenous people. You must consult the Aboriginal people before doing anything. But elections were pending, and the result was that the government of the day did not consult the Indigenous people. It went ahead with its own plan. It gave very great power to Commonwealth officials. It closed off access to certain Commonwealth benefits and so on. But in terms of taking over people's property by way of lease and so on, it had provisions for compensation on just terms, and arguably the compensation to be paid was just. And it had a process to make sure it was just. But there was one little problem with that, and it was a problem that had previously been drawn to notice by none other than Chief Justice Dixon in the 1930s. The provision in the Australian Constitution for just terms is just terms, not just compensation. The equivalent provision in the American Constitution, I think it's in the Fifth Amendment of the Bill of Rights, is just compensation, but not the same as ours. Ours was just terms. And although the statute provided just compensation, in my view, by failing to provide for access to the Aboriginal people and discussion of the proposals, it had failed to accord just terms. Now, you may agree or disagree, but it's a legitimate point of judicial choice. Chief Justice French, who had only just come onto the High Court and had only been there for 5 minutes, said that my reasoning was gratuitous. A very insulting thing for one judge. Whatever else I did, I was always polite. You look at my reasons. But he said it was gratuitous. I said it wasn't gratuitous. It was central to my reasoning. And if it's central to my reasoning, I have to explain it. But it explains a choice, and it explains an important choice, and in a very important context. If the Indigenous people, whom we acknowledge endlessly in our meetings, had not been consulted over the history of the Australian Commonwealth, the time had come to stop that. And if there was a constitutional foundation to stop it, it was the time for us to use the leeway for choice to stop it. That's what I said in my very last decision. Just terms, not just compensation. Round of applause.
So on that round of applause, I think we've come up to the hour. I think we had a very tight hour for our talk today. So I'd like to thank again Justices Kirby and Baston for their reflections and thoughts about Julius Stone and jurisprudence today, and for a really enjoyable dialectical evening. And I just want to thank as well the 3 Julius Stone Institute interns. So we have Imogen, Mike, and Tom, who've been doing great work organizing this at extremely short notice and doing research for us. And for anyone else who's interested more in legal theory, next year, start of next term, we're going to be advertising again for internships. So please consider and get in touch if you want to learn more. So again,
Internships.
paid internships. That's what we haven't had.
Very good hourly.
But we have money now, so it's paid internships. So thanks to everyone. Thanks again. Maybe a last round of applause for our interns and our speakers.
We just want to thank Justice Kirby and Justice Basson again for coming. So we'll present you with some gifts that we've hopefully chosen well, some native flowers.
Sorry for the coffee. My mother's.